Looks like we have someone logging in. The person who is identified as OGKEEK, can you turn your camera on?
Yes, I'm so sorry.
No problem. Could you tell me your name, ma'am?
My name is Kayla, Kayla, last name Hodge, Hodge.
In which case you're here on?
I am here regarding the petition for abandoned motor vehicle um, for the Hyundai Sonata in silver with the Ohio plates.
Okay. Okay. I have a Sonia Mitchell listed as the.
Yes, that's my godmom. She's also on the phone as well. I was the individual who was in possession of the vehicle at the time all the craziness occurred. So
Okay.
I.
Okay. I was just I was trying to identify you. We'll get to that when this matter is called. So today is April 11th, 2022. This is the 1:30 Civil Motions calendar. My name is Brad Gardner. I'm the presiding judge over these matters here today. It looks like we have four matters to deal with. Position one is Southern Regional versus Nikita Mitchell and Clayton County Public Schools, a continuing garnishment, or a traverse has been filed.
Good afternoon, Your Honor. Judy Nam here on behalf of the plaintiff.
Okay. And I thought I saw Nikita Mitchell. Yes.
You do, Your Honor. I'm here. Good afternoon. How are you, sir?
I'm doing well. Is this a matter that either one of you believe can be resolved by the two of you speaking in a breakout room, or is this something we're going to have a hearing over?
Judge, unfortunately, I do not have a copy of the defendant's traverse. So we would like to speak to Ms. Mitchell if she would like to speak with us as well.
Okay. Ms. Mitchell, did you provide a copy of your traverse to the plaintiff?
Actually, when I was at the courthouse and I submitted it, they told me that they would take care of getting it over to them. So they told me that there was nothing left that I had to take care of.
Okay, I'm going to request the parties to speak so that we can maybe get to the heart of the matter and possibly get it resolved. So
absolutely.
When I'm done calling the calendar, I'm going to place you all in breakout room number 1.
Thank you.
Thank you.
You're welcome. Position 2 is New Image Towing versus Honda Civic, Paul Francis.
Yes, Your Honor. Destiny Chastain on behalf of New Image Towing.
How are you doing today?
I'm doing pretty good. How are you, sir?
I'm doing well. I do not see a Paul Francis. So I'm going to presume that you're going to present the paperwork for my signature.
Yes, Your Honor. And you did say that was on the, I'm sorry, I have 3 cases with you today.
Yes, ma'am. Paul Francis. Paul Francis is the case number is 2022 CM 02959.
Okay. Yes,
if you would present that to Miss Mary for my signature, we'll get that signed today.
Yes, sir. Thank you.
Okay. Position 3 is New Image Towing versus Hyundai Sonata, Sonia Mitchell. And so we have Sonia Mitchell here, and we have, I believe you said you're her niece.
Yes, my godmom, but yes.
Godmom. Okay. So is this a matter that can be beneficial for the parties to speak before we have a hearing?
I'm sorry, go ahead.
No, I didn't mean to cut you off. I had attempted to do so once we figured out where the vehicle was. The vehicle was at a dealership for maintenance.
Hold on. We're not having a hearing now.
Oh,
the question is this a matter that can be potentially resolved by the party speaking? And if not, that's fine. I'm not trying to, push anything on anybody, but generally, if it's placed in my hands, I'm going to make a decision. Okay. It generally is better for the parties to speak so you at least know where you agree or disagree. And so we're not having a 3-hour hearing over stuff that you may agree upon. So it's up, and honestly, it's not a requirement. So don't feel like I'm trying to require you to do this. If the two of you want to speak, that's fine. And if you don't, that's fine.
We can present present the case in front of you, Judge.
Okay. Position number 4 is New Image Towing versus Nissan Murano, Michelle Evans. And I do not see a Michelle Evans. Okay. So if you will present in order for me for my signature, and for the record, that's case number 2022 CM 00650.
Yes, Your Honor.
Okay, so that completes the call of the calendar. Is there anyone that is present that believe that there is a matter that was going to be heard that I did not call? Okay, so what I'm going to do is I'm going to place the parties in position 1, Miss Nam and Miss Nikita Mitchell. I'm going to place you in a breakout room. And Miss Mitchell, do you know the basics of being placed in a breakout room? Miss Mitchell, can you hear me?
Yes, I can. Yes, we've been using Zoom to teach the children. So yes, I'm familiar with how to navigate through to the breakout rooms. Thank you for asking, though.
No, I ask because believe me, I get nervous when I have to start doing the breakout rooms and all of that stuff. I get shaky. So I'm going to place Miss Nam and Miss Nikita Mitchell in breakout room 1 so that you can have a discussion about your case in private. And then we're going to have a hearing as it relates to position number 3.
Thank you, sir.
You're welcome. The two of you should be able to click on your link and go into your breakout room. Okay. So for the record, this is going to be case number 2022 CM 01262, New Image Towing versus Hyundai Sonata and Sonia Mitchell. So because this is a petition from New Image Towing, they get to go first and tell me why I should grant your request.
Yes, Your Honor. First, I do just want to say that I have the case number as 2022 CM 02959 for the Hyundai Sonata. I think you called off the one for the Honda Civic, I think.
What I have for the Honda Civic is 02959. What I have for the Hyundai Sonata is 01262.
Okay, I apologize. I have too many folders in front of me today. Okay, I'm with you now.
No, it's fine. It's fine. I tell people the reason I've been married for almost 20 years is that I take direction well. So I do not I do not mind somebody correcting me because hey, I'm wrong a lot. My wife would tell you.
Yes, sir.
But go ahead, ma'am.
Okay, so I am showing that on November the 8th of 2021, we were called out to, give me 1 second. We were called out to impound a vehicle by Clayton County Police Department. Okay. Unfortunately, on the officer's sheet, they did not list the reason of why the vehicle was being impounded. But I do have, like I said, the sheet that they gave us when we impounded the vehicle. So that was our authority to tow. And as far as the notification requirements, the first letter is due out within 15 days of the impound. So the first letter was sent out within 10 days from the date of the tow. What happens when we impound the vehicle is we send the VIN number along with all of the information regarding the car to Clayton County Police Department, the records division. And the young lady who I deal with runs it through GCIC. And she sends me back whoever is listed as either the current registered owner, the last known registered owner. She sends me a bunch of, different addresses and whatnot. So by law, we're required to send a notice out to every single person that's listed on that information. So we are only showing the Sonia Mitchell. We have her at 1755 Lyndhurst Road in Ohio. And we also use a database called Auto Data Direct, which also pulls from GCIC. And they also yielded the same results, but this time it showed a lien holder for Ally Financial. So we also notified them. Like I said, the letter was sent out on the 19th, which is 10 days from the date of tow, to both Ms. Mitchell and the lien holder, Ally Financial. We are showing that the letter was delivered on 12/18 to the original sender because no authorized recipient was available. So we did get that letter back. The lien holder received the letter that the vehicle was here. So now we move on to the second letter, which is required to be sent out no later than 6 months after the first letter is received. So we went ahead and put that in on 1/19. We sent it to the courthouse for a case number, which was 60 days after the date of impound. We got case number 2022 CM 01262 on January 20th of 2022. So the petition was dated January 19th because that's when we originally sent it to the courthouse, but it was not sent out to Ms. Sonia and Ally Financial until the 21st, which is 63 days from the date of impound, which is still within the legal limits we're required to send these notifications out. So the second letter, which is the petition, was delivered on January 29th to the individual showed as the owner. It was also delivered to the lien holder on the 24th. Then we are showing that the owner answered the petition on February 22nd, which is where we were given this court date. So the next step in this process, since we have not filed the petition, we have not filed the motion to foreclose yet, being that the court case was pending. We do ask that the court grants us the motion just because we did notify all of the listed owners and lien holders within the time we are allowed. And like I said, we did have the authority to tow from Clayton County Police Department.
Okay, so who is going to be speaking on behalf of the respondent?
Yes. Well, I can start, and then if Sonia wants to interject to where she comes in with the notices, I was the person who was physically had the vehicle. So the vehicle itself was at the dealership, Southtown Hyundai in Riverdale off of.
Hold on, let me stop you. And the reason I was asking that question is because I just want to swear you in.
Yes, sir.
All right. So, and I'll swear both of you in now. Would you both raise your right hand for me, please? You swear affirming the statements you make during this proceeding shall be the truth, the whole truth, so help you God.
I do.
Yes.
So now you can place your hands down. This process is a heavily regulated process. Because people's vehicles and property can be taken. Do you have a legal reason that I should not grant their request?
Yes.
Okay.
So the vehicle itself was located at the dealership Southtown Hyundai for a recall on the engine. It was dropped off on November 8th towed there because it wasn't able to be driven. The dealership itself called me the next morning saying they looked at the car, what was wrong with it, how long it would take them to fix it. When I arrived to the dealership on November 11th to retrieve my personal items out of the vehicle, they were no longer had a possession of the vehicle. They didn't know where it was, who had it. I then called the police as I was there, still at the dealership, filed a police report for the vehicle being stolen. So at that point, I called my godmother, who is still the registered owner. We got on the phone with Clayton County Police Department. She gave them the right on her behalf to go ahead and file the police report. We filed the police report. Then we went ahead with the dealership because we're thinking they misplaced the vehicle, all that good stuff. So the dealership was calling tow companies. We were calling tow companies in the Clayton County area. By the 11th, the car was reported stolen. We were told nothing was found. We were in contact with the police officer who originally took the incident report. She said they put out a flag on the vehicle. If they found it, we would be notified. We had no idea that they even had the vehicle until we received the petition in January. That was the first notice that we received about them having the vehicle. Upon calling, I spoke with the manager of South Image Towing, and it wasn't until I informed him that I was already at the police station that I even got a totally separate case number regarding this vehicle VIN stating that it got towed. Clayton County said they have no idea how they didn't authorize this or how the VIN came up twice. And so legally, we're requesting that you not grant their request because the vehicle was parked in a proper dealership. We weren't informed. She stated herself that they received the notice back. So we never even received the first notice because they received it back. The vehicle was paid for in full. So there wasn't a lien or any kind of hold on the vehicle because Sonia Mitchell owned the vehicle outright. So we would have never gotten any notifications about them having the vehicle on their tow lot or anything like that unless we received those letters like we did the petition, in which I responded to after dealing with a court-appointed community lawyer, which I got in contact with via the government.
What is a court-appointed community lawyer?
That's the term he used. I'm not sure. That's the term he used. It was a free database that I got told to use at the records department in Clayton County in order to find someone that it could explain what we needed to do.
That doesn't exist.
Okay. Well,
that does not exist. It sounds like your position is that New Image Towing illegally towed your vehicle and they're now holding it to extract money out of you. Does that sound fair?
Yeah.
Do you understand that if they were doing that, they would not only lose their business license, that someone could go to jail? What information do you have to support that contention? Because it sounds like you said you contacted police and it was safe. No, hold on. Listen to me. Listen to comprehend. Don't listen to respond. Sounds like you should be filing a police report. Have you filed a police report against New Image Towing?
Yeah, the original police report was filed against the dealership. And then when I went back, which is how I got the new case number that she has for the vehicle, is when I went to file this motion and put a police report on New Image Towing. When I went to file the motion, the young lady at the desk told me to wait to come back for the hearing.
Ma'am, so sounds like the answer to my question is no.
No, the only police report I have is from when the vehicle first came up missing against the dealership that had the vehicle in their possession. That is the only police report I have.
So, ma'am, if what you're telling me is true, you're sitting on the biggest lawsuit that you could ever sit on. And I don't understand why we're here.
Well, because we received the notice and I was informed by Clayton County courts and the lawyer that I was working with at the time that we needed to respond back to this motion that they filed and appear to the hearing. So that's why.
Yes, you should do that. But I don't know this community lawyer stuff. I honestly have never heard of that before. The issue is this, man. Because this is a highly regulated industry, if the towing company steps out of bounds, they risk losing millions of dollars. And they, for that reason, very rarely step out of bounds. A towing company essentially becomes what's called an innocent owner, meaning if they're called out for a service and they perform that service, they're not held in the same position as if they just rolled up to your house and took your car out of the driveway. My understanding from what New Image saying is that they received a call from Clayton County to come get that car, which means there's a record of the 911 call. There is a record of the incident report. If Clayton County called New Image Towing out wrongly, then New Image Towing, not New Image, I'm sorry, Clayton County would be responsible. I need to hear how they have violated what they're supposed to do.
Well, and from the conversation, not notifying us in the proper amount of time, the vehicle was reported stolen 48 hours after they had the vehicle on their tow lot. At that point, I was working with Clayton County police officers to find the vehicle. They had the VIN number, they had all the information. When I asked the officer who I was working with, Officer Khatib, she informed me that you have to go to the records, get a copy of the incident. When I went, they informed me that it had to be mailed to the registered owner, which is my godmom. So she requested for the incident number. The number that Court and County gave me was totally different from the court case number that New Image Towing gave me when I was on the phone with New Image Towing's manager. So on my end, I totally understand what you're saying as far as like who is responsible for what. On my end, I'm just trying to figure out essentially like there is a responsibility that has to be taken because this car have paperwork showing that not only the dealership signed for the car on their lot, the dealership still thought they had the car when I came to get my personal items out of it that morning. I was walking around with the key, chirping it in the lot, and the car wasn't there. I don't know. My question is how between all of this between April and November, no wires got crossed with the VIN number. There's 2 open cases on this vehicle with the VIN number, 1 reported stolen, 1 a pickup by the police. But when we're contacting New Image Towing, I'm contacting the dealership, I'm contacting the police department. Everyone's giving me, well, we don't have it, we don't have this, we don't have responsibility for that, we don't know, talk to them, get this, get that. At this point, I'm kind of just as confused as you are that my godmom is all the way in another state. That car was gifted to me after it was paid off in full, and I was responsible for the vehicle. I took it somewhere thinking it was getting fixed, and it disappeared out of thin air. 4 months later, we get a letter saying that it's been with New Image Towing since the day it got towed there. It got towed there on November 8th. So it got towed there and towed away in the same day without any contact. So I'm just trying to figure out what I should do now because I'm just following the steps I'm being told.
No, I understand. And I'm certain if you request the information, New Image Towing will show you the documentation as to why they were called out.
See, the manager said he wouldn't. So that's again why we decided to come to the hearing, because the manager said he wouldn't without going to court. The court said they couldn't without sending something to Ms. Mitchell first. She's already sent something back, but now she's responded, but now we're here for the hearing. At this point, we haven't heard anything back from them with her.
And I don't know this community lawyer person, but generally in civil cases, people are told that they have a duty to mitigate their damages, which means that, if there is a hole in your roof from a storm, before you can get it fixed, you have a duty to mitigate your damages, mean put a tarp over the roof so that everything doesn't just flood into your house. And then we deal with the damages later. Your duty in this case was to, even though you felt as though you were being wronged, was to mitigate your damages. Pay the bill, even though you disagree with it. Pay the bill, get your car back, and then sue everybody to get paid, not only back what you paid for the car to get the car out, but to then go and seek punitive damages because of what has happened. You're not in a position to do nothing and let the fee, because the fees go up every day. And then come to the court and say, well, hey, I've been done wrong. I want my car back. Okay. From a court's position, when you're talking about abandoned motor vehicle, if the towing company has done what they're supposed to do, my hands are tied as it relates to that. Doesn't mean you can't recover from the people based upon what you testified here today that may have acted in a negligent manner that allowed your car to get towed and then possibly losing your car. So you do have a remedy, but the remedy is for me not to ignore the law. If that makes sense to you. And I know you don't like it, but I'm just saying, does what I'm saying make sense to you?
Mm-hmm.
So I'm gonna ask you, give you one last opportunity. Do you have something that I can look at from a legal standpoint to make a decision? And Ms. Chastain, I know your company, your business, and what you all have to do. If what I've been told is true, I mean, New Image Towing has clean hands in this matter, which means they're not necessarily sitting in a situation where they're going to face some kind of civil liability. But if they received a call from Clayton County to come tow this car, and you're saying that it was towed from a dealership's lot, those are the people that you have a beef with. So I don't know, and that's what I'm saying, because I don't know if there's even like the ability to have a conversation about how you can recover your car, even while this is waiting. Because if what you're telling me is true, it's not about when you're going to get. It's not if you're going to get paid or recover. It's when. But unless you can show me that they've done something outside of the law, I can't just, because I feel bad for you, I can't just break the law.
Right, totally understandable. Am I able to ask a question?
Yes, ma'am.
Okay, my question would be, if it's, I don't know, maybe I'm not sure how to word the question properly. Essentially, what I'm trying to,
Just say it. Just say it.
so essentially what
I'm an adult. I'm an adult. I can take
so
it.
yeah, so essentially what I'm trying to figure out is, if the dealership is claiming that they still had the vehicle, literally till the moment I was physically on the property, meaning that nobody had knowledge that the vehicle was even picked up at all, how then is it considered an abandoned vehicle if no one knew that the car was picked up? If we weren't alerted, if the car was then placed in a situation where it was marked as stolen and the VIN never flagged or anything with the tow company, with anybody else saying, hey, this vehicle has now been reported stolen. All of those things would be things that, I wouldn't have a way to flag to them or no, I didn't know New Image Towing existed until we got the notice in January. I didn't knew anything about it.
So, under Georgia law, an abandoned motor vehicle is basically a term of art. And so your vehicle, you could have taken it to a repair shop to get it repaired, paid them the money, and for whatever reason, they call a tow company to come get the car. The car is considered abandoned. And that's where there are like notice requirements. There's like, it may not be your current address or whatever, but they have to go through the steps of figuring out the address that's attached to the vehicle and sending notice out to that address. So it may not be your address, but as long as they've sent it to the address that's attached to the vehicle, they've done what they're supposed to do under the law. And so then it becomes.
So then once it got sent back to them and they knew that we didn't receive it, then what would have, because then the next step, they didn't file anything again until months later. So if the first notice got sent out and as she stated, they received it back, which means they knew that the person that they were supposed to send it to didn't receive it, then I think that's kind of where I'm getting confused, because if they know we didn't get the first notice about them having the vehicle, months later, I guess my question is the Clayton County, because I've been to the Clayton County courts within these past few months, requesting paperwork, requesting documents, trying to get incident reports, trying to get information. And you see what I'm saying? And I just wasn't.
I do.
Nobody had anything to give me until they filed this petition in January.
I'm sorry, Ms. Chastain.
Can I interject?
Yes,
I think I can answer her question. So by law, if the first letter comes back to us, we are good to move forward with the petition. Now, if it would have said, awaiting scan, anything like that, showing that there was not an attempt, because it is showing that there was no authorized recipient available, then we had the right to go ahead and move forward with the petition. Given the time frame in between, just being 100% honest with you, we have over 1,000 cars on our lot. So there is a little bit of delay, but we are allowed by law 6 months. So we could really wait until the very last minute to notify you. But as I said, we try and get them out as quickly as we can, but we do have a very big inventory. So there could be a couple of months delayed. But like I said, as long as we fall within the law to send it out within 6 months, then we are covered. I know that is kind of crappy towards the customer because, like the judge said, it is accruing fees this whole time. But as I mentioned, it's kind of a sticky situation with what the law allows us as far as time frame goes, and then with how many vehicles we have. We're constantly notifying people. We're constantly working as quick as we can. But when you have over 1,000 cars and bringing in 20, 30 every day, there is going to be a little bit of gap in between when that first letter goes out and the second one does. Now, if the second letter didn't go to you, like if the second letter came back to us, by law, we'd have to run an ad in the local newspaper for 2 weeks, but that's only with the petition. The first letter is a little different under the law. As long as we get it back, like I said, as long as it doesn't show that it's like lost in transit somewhere, we can go ahead and move forward with that second letter. But we did still allow 10 days, which is the time frame, you know, whether you got it, whether you didn't, we have to allow 10 days before we move forward with that second letter.
So
No, and that's what I was going to say is that their duty is not for you to receive the mail. It's there to send it to the known address and for them to show that they've taken steps to find out what address is attached to that vehicle. And as long as they do that, they follow what they're supposed to do.
So they
And
don't
so
get notifications when a vehicle is reported, because the vehicle was reported stolen 48 hours after they had it. So the VIN.
how would they know that?
That's that's my question that I'm asking, if Clayton County are the ones that told them to pick it up. Once I filed a police report on that same VIN number for a car that they already had an incident report out on, I'm just wondering how the things didn't overlap from the court to them, maybe is my question. Because if they, when I spoke with the young lady at the desk at the records office, she told me, well, I don't know why this wouldn't have popped for the officer when you filed for the car being stolen, that no, hey, we had this vehicle towed 2 days ago.
Which is why I said you're sitting on a sounds like a pretty good lawsuit to me.
Can I ask the date that you filed the vehicle as stolen, that you reported it as stolen?
Yeah, November 11th at 9 a.m.
Okay, because so as I mentioned before, when we impound the car, we have 72 hours to notify the local police department that we have it. So we sent the VIN number over and all of that information on the 10th. So that's why we didn't get the stolen pop, because you didn't report it stolen until the 11th, but we had already received the owner's information on the 10th. So we don't rerun it again once we run it that original time. And I can tell you that I deal with a lot of stolen cars. So if it was reported stolen when we ran the VIN, then we would have been notified and we would have had to gone through a different process. But because we ran the VIN before you reported it stolen, we didn't get that red flag that you had reported it stolen.
Yeah, so it's just a messed up situation because I didn't know it was stolen, because I'm thinking it's at the dealership getting fixed, and the whole time it wasn't. So that's where that crosshair comes in it. And the
I did
dealership.
want to note that the officer sheet says November 8th, but it is showing at 23:49. So it looks like 11:49 p.m. is when it was dated. And it actually didn't get to our yard until 1 o'clock in the morning. So we got it technically on the 9th. So I'm not sure. I know you said you dropped it off on the 8th, but like the judge said, we wouldn't have been able to come out and remove the vehicle unless we had the police call us out, which is where Clayton County comes in.
And ma'am, tell me your last name again.
Hodge, Hodge.
So, this is I'm legally constrained from asking or giving you the relief that you're asking for. But Ms. Chastain, let's assume everything that Ms. Hodge said is true. I know your company is, you're not in the business of just doing crazy things, but if what Ms. Hodge is saying is true, like I said, I think she's sitting on a very good lawsuit. And Ms. Hodge, I don't believe Ms. Chastain is working at cross purposes with you. You said the vehicle was not running.
Yeah, that was my confusion, because it got towed there on the 8th because it caught fire while I was driving it. I was on the freeway and it combusted. So I had it towed to the Hyundai dealership there because it was still under the warranty. And that's where I think when I was talking to the manager of the towing company, he was also confused because I was like, well, the dealership themselves called me that morning, which it states in the police report saying, we just got done looking at your car. Here's what's wrong with it. It'll take us 3 months to fix. If you want to come get your items out of the vehicle, you're more than welcome. I said, great, I will be there Thursday morning, 9 a.m. when y'all open. I showed up, they handed me my car key, and what the car wasn't there. And I was there for almost 2 hours while they kind of ran around and had no idea the vehicle was missing. So that's why I said I didn't even know new image towing was a thing, because the dealership was ensuring us, the police, and my godmom that they were calling all the tow trucks in the area, calling all the lots that they work with, calling everybody that they could to figure out what happened to the vehicle and where it was. So that's why I was like, well, it wasn't until January that we even knew that New Image Towing had the vehicle. And then in between that, I've spent the last few months going back and forth between Clayton County courts and just working on like, what information do I need? I have recorded conversations with the permission of the manager of the dealership stating that, yes, we took the vehicle onto our lot. We had it in our possession when we closed that evening. We have no idea where it went and why. It wasn't until after we received the notice from New Image Towing that the dealership called me, and they miraculously have video of the vehicle being taken off the lot by unidentified individuals, but they were refusing to give me the video footage or turn it over to the police. At that point is when the young lady gave me the link to a free service to look up the lawyer situation. Anywho, that's kind of where I'm at. Just as confuzzled and to make you scratch your head, that's what we've been doing for the last few months, because we are kind of in limbo here. We don't know what's going on. The car just vanished, and we're sitting in a position where we're like, well, we've been looking, I've been coming to the courts, I've been given information, we've been paying for copies of records, and it wasn't until this notice came that we heard anything about an incident report and the car having to get picked up.
Okay, so I'm gonna make a ruling that if New Image Towing wants to move forward, I think they've proven that they have that ability under the law. But and I'll just speak out loud. I'm just speaking. It sounds like this vehicle isn't worth a whole lot. And it may have sentimental value to you. It may be something that you want. That's fine. It may be something that there can be a discussion had and potentially an agreement made to have New Image paid their fees out of the big fat lawsuit you have sitting in your hands. I mean, but that's up to the parties, how they want to proceed. Again, I have to follow the law. But
Your Honor, can I
yes,
just advise what the fees are at right now, so she has an understanding of what she's looking at?
Sure.
So as of today, the total fees for the vehicle to pay it out, pick it up, is $4,125. And that goes up by $25 every day.
And I'm going to encourage you, Ms. Hodge, to not go back to the community lawyer. There can be an agreement reached that, hey, this amount is owed. This is what has happened. I'm going to go sue these people, and I'm going to pay you this amount of money out of the money that I'm getting from these people, because based upon what you just said, this is a minimum amount of damages that you would be owed, because of the apparent negligence of either the dealership or the officers. And I don't know, but that's something where you can't get a community lawyer. And civil lawsuits, lawyers oftentimes they will charge a contingency fee where you're not paying anything out of pocket, because the lawyer looks and their eyes get big and they're like, ooh, it's a bunch of money right here. So they take it on knowing that they can recover on the back end.
Okay.
I would encourage you to consider that.
Okay. Is there a way that I can, Sonia and Ms. Chastain, I don't know if I'm saying your name correctly, could speak and work something out so that we can try to move forward with this process? Because I agree. It just put with the, like you said, the car doesn't have a lot of like numerical value, but it was my only transportation. Like I don't have a car at the moment.
Right.
Because of this situation. So this is, I definitely want to move forward with your advice. If Ms. Chastain is willing to see what we can discuss us three together and go from there. I'm not sure, what she has the ability to do.
You can call New Image Towing and have a conversation.
Okay.
Now, I have to tell you, I didn't advise you. I can't advise you as a judge. I was just speaking out loud.
Absolutely.
Okay, so Ms. Chastain, I would hope that you speak to Ms. Hodge, and I don't know if there's an agreement that can be reached or not. I'm definitely not requiring the parties to enter into any kind of agreement. But sometimes, as we used to say, I'm older, but in the olden days, you sitting on the porch, just rocking, sitting and talking in the rocking chair. Sometimes some of the best ideas and some of the worst situations get worked out.
Heard.
Okay. All right. So that's going to be my ruling as it relates to case number 2022 CM 01262. And Ms. Chastain, that's your final case. So you are free to go.
Thank you, Your Honor.
You're welcome. We have Ms. Nam and Ms. Mitchell back. And Ms. Hodge and Ms. Mitchell, Sonia Mitchell, you both are free to go and try to reach out and see if there's an agreement that can be reached.
Absolutely.
Thank you.
And get a lawyer. Get a lawyer. Okay.
All right. Thank you.
Okay. Bye-bye.
You're welcome. Okay. Ms. Nam and Ms. Mitchell, what's the report?
We're ready to proceed.
Okay. All right. So this is case number 2022 CM 20193. This is a garnishment action, and there was a traverse filed by Ms. Mitchell, correct?
Correct.
Okay, so this is your motion, Ms. Mitchell, so you get to go first.
Unfortunately, because this is not something I've ever had to navigate through before, I hope that you'll bear with me, Your Honor, and Ms. Nam. We spoke when you had us in the breakout room, and I made her aware that number one, I had reached out.
Hold on. Let me swear you in, Ms. Mitchell. Raise your right hand. Do you swear affirm and statements you make during this proceeding shall be the truth, the whole truth, so help you God?
So help me God.
So what I'm going to ask of you, Ms. Mitchell, I will give you grace and leeway. But what I need to hear is, why should I rule in your favor? Not like a whole story, but why should I rule in your favor?
Number one, the notice was legally insufficient because I just received this information. Ms. Nam was telling me that I had been served some time ago, some years ago. I don't recall ever having been served. And she actually, I was asking her about dates of service because these are medical bills. I didn't realize that this case number was different. The case number for the actual garnishment was different from the case number that her staff member sent me with that had the information. So I actually need to go back to come back up to the courthouse and get the information from that from when the initial garnishment, I guess, was put in, so that I'll know what the dates of service were, because I don't even know what these bills pertain to.
Hold on. Ms. Nam, what are the dates?
Your Honor, I'm happy to give the dates of the service, but I believe that's irrelevant to this matter right now. We have a valid judgment from the Magistrate Court of Clayton County that was filed back in 2016, and that's what this garnishment is based off of. She's talking about service, and that is the service related to the original underlying claim, underlying judgment. We have sent her.
Miss Nam, you know, the one thing I hate as a judge is when I ask a lawyer a question and they don't answer it.
Yes, Your Honor.
I know the law. Please don't explain the law to me. I know it.
Yes, Your Honor.
I'm trying to move this stuff along, right?
Yes,
so
Your
we
Honor.
don't need to fight. So she says she doesn't know when the dates are. If you know the dates, give her the dates.
Yes.
Is that hard? Is that hard?
No, Your Honor. I'll give you the dates.
Thank you.
There was two separate visits for this underlying judgment. It was September 9th, 2012 and January 29th, 2013.
September 9th of 2012 and
January 29th of 2013.
My apologies, sir. I work at an elementary school, and I'm actually in the janitor's closet.
Ma'am. It's okay.
Okay.
I have children. I have dogs. I have cats. I'm not that person. Ma'am, were you in the hospital on September 9th, 2012?
Yes.
Were you in the hospital on January 29th, 2013?
Not that I recall, sir.
Okay. So you agree to one day that they're asking for you to repay medical bills, correct?
Understood.
So for this, at least one day, there is a valid judgment.
Understood.
Okay. Now, when we move to the second day of January 29th of 2013, Ms. Nam, I'm going to give you an opportunity to answer another question for me.
Yes, Your Honor.
When was the lawsuit filed as it relates to the 2013 date?
It was filed on April 25th, 2016.
And do you have a service date?
May 8th, 2016.
Okay.
It was, yes, that is the date.
Okay. And was there an answer filed?
No.
Okay. So, ma'am, that means it's a default judgment.
I understand. I understand that as well. But like I said, I mean, if I didn't receive the paperwork, how would I have the opportunity to respond? That's like what the proverbial tree falling in the woods. If I don't know it exists, I can't offer a response.
So, there are legal means to challenge that. When we get to this point, basically, those legal means to challenge that were not followed. And so, again, as a judge, my requirement is to follow the law. It's not to listen and try to bend the law, change the law, because I like one person or another person. So when you get to this point, you're pretty much kind of at a point of trying to reach an agreement about how this debt will be paid. It's not to go, you can't go behind the debt.
Oh, not by any means, sir. I mean, like I said, I just wanted clarity as to what it was for, because I have had a circumstance where there were some medical bills that were not mine. And basically, I guess you could call it identity theft.
Mhm.
When I was pregnant, someone actually used my pregnancy Medicaid. They had my information and they used my pregnancy Medicaid and had some services done that were not my services.
Mhm.
And it was something that I had to reach out. I never had to come to court about it, but I had to go through some stuff with Medicaid and the hospital and stuff to get it resolved. So my thing is trying to make sure that these are actually my bills, because I don't have a problem with paying my bill. I don't have much money. So I have a problem with paying my bills, but I just want to make sure that these are my bills, being that, like I said, this is like a quarter of my check coming out, and I'm a para in Clayton County, so
No,
I need all mine. So that's my only thing, Your Honor. I just need to know that that's why I was asking about dates of service and trying to get some information as to what was done. Does that make sense?
it does. And those dates that we just
The
heard from,
September 9th, absolutely. I do recall that. If I'm not mistaken, that was when I was in the hospital for kidney stones. But January 29th, 2013, I'm not familiar with. I don't recall being in the hospital at all in 2013 until the end of the year when, well, never mind.
no, I understand. So what you can do, Miss Mitchell, now that you know the dates of the April 16, 2013 of the filing of the lawsuit, you can look those records up.
But from what
And
you're telling me, either way it goes, I have to pay the entirety of the judgment, even if those are even if I find out information that that substantiates that this is not mine from January 29th. Am I correct? I still have to pay the entirety of it. Am I correct in that?
okay, Miss Mitchell, now you're about to get on my second pet peeve of when I'm speaking.
My apologies.
I am trying to give you information. And generally, if you listen to what I'm saying, you may not have questions. Okay.
Yes, sir.
So look up those dates as it relates to the lawsuit. See what the lawsuit says, because it'll say on these dates you received this service. Then you go back in your calendar and you're like, hey, I was in Jamaica on this day. Absolutely no way could I be at Southern Regional Health. You then call the police and file a lawsuit. I mean, not file a lawsuit. You call the police, file an incident report. Somebody cloned or stole my identity. I now have this judgment that is against me. I was in Jamaica. I am not responsible for this. They then look into it. And because this is a default judgment situation, if the police are like, hey, Brad Gardner was at Southern Regional on that day and he used her social security number. Brad Gardner is being prosecuted for this. Now you have something that if you can't get out from under this judgment, you at least have something to show that you were in Jamaica and Brad Gardner did this. So then the lawyer has to decide if they're going to move forward collecting a debt that they have reasonable belief was fraudulent. If they want to do that, hey, they can do it. But they may do it at their peril. Better yet, you have a person that you can go after to collect so that the money that you've had to pay, you can collect that money back. So I say this all to say, ma'am, I don't try to be harsh to people, but I do have to follow the law. And you know, stuff happens. Do you have any other questions, Ms. Mitchell?
No, sir.
Okay, so the traverse is going to be denied. You now are armed with dates and information that you can go and figure out what happened with this January 29th of 2013. Because I mean, the unfortunate thing, and I see it all the time as a judge, it's family members and brothers, sisters, and all kind of stuff happens. And people get caught up in it. And it's like you said, hey, I don't remember doing that. I don't remember being there. So there are steps that you have to take though. Okay.
Yes, sir.
All right. So traverse is going to be denied. That completes the call of this calendar. Thank you all for your patience. Have a good day.
Thank you,
You as
Judge.
well.